If you have a separate will, secondary will, in Ontario and a few other provinces, you have a secondary will for just the shares in the corporation, that can bypass the estate administration tax. Welcome back, everybody. It's great to be back. I've really enjoyed doing the first couple of episodes, and today we're going to be talking about the other inevitability in life, death, in addition to taxes. There are a lot of considerations when you die on what's going to happen to your crypto, particularly how to store it and how you manage it, what your executors need to do, whether you need to use trusts. I get a ton of questions about trusts all the time. A lot of the information out there is also about trusts because it comes from the United States, where it's used totally different than it is here in Canada. There are a lot of different things you can do to protect your estate, to mitigate taxes, and to insulate your crypto from liability. I've been doing wills and estates work for a long time, and I can tell you that people always put it off because it's an admission of mortality. People think that as soon as they do a will, they're going to die. So, but you don't. But on the other hand, if you don't do it, it leaves a lot up in the air to your family and your beneficiaries and things. So I think what's important, though, is that we should talk about today what your options are. There are three major types of documents or structures that people use: wills, powers of attorney, and trusts. So I'll go through each one. Will is a document that you create to gift your stuff after you die. It's intended to just gift stuff. Okay, so we don't want wills to go on and on and on. We want to be able to you have beneficiaries who you're going to gift your stuff to, and you have an executor whose job it is to make sure that whatever's in the will gets done. Power of attorney is while you're still alive, but you can't make decisions for yourself. There's two powers of attorney. One for care, which we're not going to get too much into here. It's about whether, the whole pull the plug clause and whether you're, stay in a nursing home or go home and have, nurses taking care of you. It's when you have a prolonged incapacity. But there's a power of attorney for property, which allows people to access accounts, bank accounts, investment accounts, anything that isn't joint with somebody else. And then there are trusts, and trust is designed for, like I said, a will is you give things away right away. Trusts are when they are drawn out a little bit, and they're used for different purposes. So if you're just giving your stuff away, will, you can build a trust into your will. It's called a testamentary trust, where you can give things away over a longer period or hold it in trust for minor children, things like that. So your major options here that we're talking about when we're talking about estate planning are wills, powers of attorney, and trusts. First, we have to look at what your intentions are. And if your intentions are insulated from liability, if you're worried about liability, if you're worried about privacy and protection, then often we don't want things becoming public record as it would be with a will. So with a will, you can gift everything that you own to somebody and they'll receive it. But when you probate a will, in other words, when you go to court to make it legally enforceable, it becomes public record. So you got to be careful there if you want to keep things private. You don't need to, because it won't really affect taxes too much if you're gifting things to people. But the main thing to remember is that if you're looking for asset protection and if you're looking for some tax protection, trusts can be useful. But keep in mind that one of the principles that you have to keep in mind with tax and estate planning is the more control you give up while you're alive, the less tax you'll pay, but the less control you'll have. So on one end of the spectrum, you can gift as much cash as you want to anybody in Canada, tax-free, but then you've given up your cash and it's gone. Okay, so you can also add people jointly on title on real estate, for example, but then you've sort of given them an interest in the property. When it comes to trusts and protecting yourself from tax, when you settle a trust and you start putting assets in the trust, you should have 3 trustees who will have a say over what happens to that. You can be a beneficiary too. Even a corporation of yours can be a beneficiary. Well, if you have just one trustee and you're the beneficiary, then there's no separation of legal and beneficial ownership, and it might be considered a sham trust. It doesn't really fit the rules of a real trust. And so if you're trying to benefit from the trust, you wouldn't really, it could be challenged on those grounds. So typically, if you're a beneficiary, you want 3 trustees. And the more trustees you add, obviously, you have more people having a say on how these assets are being used. But when you pass away, those assets won't be forming part of your estate for the tax reasons, because the trust is the legal, like the trustees are the legal owners. So you may have passed away, and whatever you owned personally, it sort of separates that. So you have that privacy from a trust, you have asset protection, but you are giving away control. And there are 3 major kinds of taxes that we have to deal with. There's in Ontario and in a number of other provinces, there's the estate administration tax. So the estate administration tax, if you probate a will, so if you have assets that you passed away now, and you pass away, you can't use your powers of attorney anymore once you're gone. So if you had someone who had access to your safe deposit box or your bank accounts or your trading accounts, exchanges, things like that, because of the power of attorney, they can't use it anymore. So now you have to take the will to court and get an order from the court. It's called the Certificate of Appointment of Estate Trustee. And it used to be called probate. I guess that was kind of colloquial now. But it's a Certificate of Appointment for Estate Trustee. And once you get that, depending on where you live, it could take a couple of weeks or it could take several months. Toronto, for example, a very big backlog, lots of people dying here. So it can take 6 to 8 months to get a certificate of appointment, as opposed to the court in Coburg where, you might get a phone call within a week from the estates court letting you know it's ready to go, depending on, how many people are in the queue on that. Well, you have to file where the person lived when they died. The second thing that this sort of segues into the other kinds of taxes, there's capital gains tax that you potentially have to pay. So in addition to the estate administration tax, when you die, you have to file what's called a terminal tax return as of the day that you died. And that's based on the fair market value of everything you owned at the time that you died. And it's an income tax, right? So there's 2 kinds of income tax. There's capital gains and income that we talked about before. And so capital gain are things for capital assets. It could be your crypto. It could be rental properties that you own. Your principal residence is exempt because when you sell, your principal residence is tax-free. If there is any capital gains tax to pay, then the estate pays it, okay? And when you gift assets, the estate pays whatever taxes are owed. If you have some crypto and you're gifting it in your will to a beneficiary, they will receive it tax-free, but the estate will have to pay tax on the fair market value as if you disposed of it on the day that you died. And whatever the gain was from the time that you bought it, 50% of that comes in income if it's a capital gain, and then you apply the marginal rate. Even if you rolled some of your assets into a corporation, the estate will be taxed on the value of the shares of the corporation, which are capital assets. Now, here's an exception to that, though, and this is a really good one. If you have a separate will, secondary will, in Ontario and a few other provinces, you have a secondary will for just the shares in the corporation, that can bypass the estate administration tax. So that's good. You can skip one layer of tax just by doing a separate will. And typically those types of wills only cost, not a lot of money. If you use a will, you're really saving taxes for your beneficiaries because the estate will end up paying the tax. So there are 2 out of the 2 inevitabilities in life when they cross over, death and taxes. When you mix that with crypto, it gets even more interesting. And so you have to make sure that you know where the cold wallets are, if there are any cold wallets that hold crypto, if you have any on exchanges, you have to let people know. Never put private keys in any of these documents. Never put them in wills because that could become public record. And you don't want people to know about how to access your crypto. That would be the worst. Thanks again. This is the show for today. Remember, if you reach out, happy to give 10% off. You mentioned the podcast, the CrypTax podcast. And I hope this was helpful, and we'll see you next time.